we have a question from Kay Black. She says, I'm trying to prove ineffective counsel. How can I get the information needed? Whew, that's a tough one. So, and those of you who have listened to our videos or check out our Facebook on any type of regular basis, know that ineffective assistance of counsel is one of the main arguments you bring in an 1107 writ, or an 1107-2 or 1109, whatever kind of writ it is that you're filing. And because it's a constitutional violation, right? You're guaranteed effective counsel by the 6th Amendment, and if you are not provided effective assistance of counsel, then you can argue that that right was violated and you're entitled to relief. So, but to prove that, right, that's the difficult part. And I will tell you, we talked about the 2 prongs of Strickland, right? You have to prove that, yes, your attorney made a big mistake. That's usually the easy part. The second part, you have to show that that mistake harmed you in some way or harmed your loved one in some way. That's the hard part. Because mistakes are made all the time, right? Attorneys are humans, they make mistakes. Now, whether those mistakes really harmed and negatively impacted a person's case is the question. So the information that you need to gather, that you asked about, would be first and foremost the trial counsel's perspective, right? Because you cannot go to a court and say the counsel was ineffective and not provide that counsel's side of the story. Like, we don't know if they can justify what it seems like they did or didn't do, or, you know, if it really is an error that we should be considering. So if you don't have the trial counsel's perspective, don't assert ineffective assistance of counsel. The perspective of trial counsel is number one. And of course, when you're arguing what they did wrong, you just need to explain that well, right? You cite from the record if that's what happened, if they made a mistake on the record, or if they failed to provide mitigating evidence, or if they failed to inform you of everything, all the facts and law surrounding your plea, those kinds of things. And you can also provide an affidavit from the defendant to lay out those things for the court too. But the perspective of trial counsel is of the utmost importance on those kinds of claims.